what he thought was an assertion of a disability. And there has been nothing put in the record which would support an assertion that there wasn't a disability. There's no medical records that have been offered. There are no, there's nothing from your client which, for lack of a better way to describe it, refutes what the referee has concluded. And so how do we deal with that?
Okay. Well, just as in any other case, if you're looking at the findings and there isn't any documentation to back up those findings, well, maybe those findings aren't supported.
Well, we have, as I understand it, the assertions made by your client's husband, the fact that the assertions, whatever they were, that you made at the time of the hearing, we have all of that in the record. Mm-hmm. And that seems to be, one could argue, supports the referee's conclusions mm-hmm. and findings. But there is nothing to counteract that. And through all of these proceedings, nothing's been submitted.
And I would say that in my subsequent letter to the referee that I did indicate that we could produce medical records. But you see, there's also that issue about confidentiality of the medical records as well. And that was not really addressed. And that offer of proof was made. And certainly, if you feel inclined that there should be a hearing to place Ms. Clark on disability inactive status first and then have a hearing is backwards in my mind, as I mentioned in the memorandum. You should really have the hearing first and have that medical documentation and have a hearing, an evidentiary hearing, where you've got the evidence to go on, and then have that referee decide yes or no, is it really a disability or not.
So, counsel, you offered to provide medical records under seal to the referee?
Yes, I believe that in that letter that I sent on the Wednesday following the appearance that we said that, yes.
So there isn't a problem with then privacy as it relates to the medical records if in fact they are submitted under seal. Is that correct?
They would have to be under seal. Correct.
And you offered to submit them under seal?
We don't have any problem with them as long that.
So I'm asking whether you offered to submit them under seal so that the referee could consider them and that they could remain confidential.
We offered that, yes.
Okay.
Yes, and if I could, I would like to have Ms. Clark come up for the last 9 minutes to further with our response.
Good morning. I'd like to address questions if you have them, but if you indulge me for a moment, there are a few things that I would like to say. First of all, appearance here today does not waive respondents' right to move to disqualify Craig Klausing and Martin Cole. I am commencing a lawsuit against them for falsely imprisoning me on June 15, 2012 in the Office of Lawyers' Professional Responsibility. That incident was so traumatic to me that it affected every day of my life after that. And if the proceedings here are to reward them by taking my license because of how they've treated me, I think we have a problem. My diagnosis as I stand here today, which I was just able to get after diligent effort, it takes a long time to matriculate through doctors and hospitals and tests. It can't be done in 2 days as the referee was expecting. I'm entitled to a second and third opinion. I needed a fourth and fifth opinion. And my diagnosis as I stand here today, the seizures have resolved. There are theories of what caused them. I won't go into that, but those are gone. No medical evidence of that here today. But what I do suffer from is post-traumatic stress disorder, and it is very clear that the trauma is treatment by judges in this system. Judges Wieland, Zimmerman, and Blazer, and their conduct and the way that I was treated in this disciplinary proceeding have caused me extreme trauma. And yes, I am disabled from that. But if you are going to reward that conduct by giving them my license, I don't think that protects the public at all. There was never a case on the merits, and I think everybody knows that. This case was never about lawyer misconduct, and it was always about judicial misconduct, and that is what the public needs, is explication of judicial conduct. And when certain evidence emerged in this case, I was falsely imprisoned, my home was broken into, my office was broken into, my computer was broken into, every time I got close to exposing judicial misconduct. And yes, I was hospitalized before the hearing on June 25th because I broke down and they broke me. And if you are going to reward them for breaking me by taking my license, I think that is the question before you. I think if I can put my lawyer hat on for a moment, you have to look at the meaning of the word disabled. I think Ms. Longree said it best. If I'm blind, and I say, I have a disability, I'm blind under the Americans with Disabilities Act, I need a reader at my disciplinary hearing. Under this rule, they could say, well, sorry, now we get your license. We don't have to prove any misconduct, we just get your license because you said you're disabled. That can't be the reading, or if it is, your statute is preempted by federal law. The reading has to be read, a disability, and therefore is unable to assist in the defense. But it can't be simply hospitalized. Otherwise, you're in a car accident, you break your leg, you're in the hospital the day of the hearing. But a week later, you're on crutches and you can come. My issue was the seizures were diagnosed, but the trauma wasn't being addressed, and that's just the way it happened. The doctors addressed the most emergent issue at the time. The trauma is now addressed. I think you can see from the accommodations that were requested for this hearing, I mean, one of the reasonable accommodations I'm requesting has probably never been done before in the country, but I'm requesting that judges not yell at me anymore. I've been yelled at for 4 days straight at times. I've been treated abominably, and I think we all know why that is. And I just can't take it anymore. But that doesn't mean I can't assist in my defense. It just means maybe like the rest of the world, judges should not be allowed to just haul off and eviscerate someone verbally. That's what I'm requesting. A break, breaks when I need them. Maybe half days. But there's no reason I can't assist in my defense. Tomorrow is premature. I do appreciate the question from Justice Anderson. I would need to clear all this. I have a number of professionals, as you would imagine, even being here today. I had to clear that with professionals to make sure I'm taking care of myself. And you know what? There is collateral damage, and there is damage to clients. There's been damage to my clients for many years in the Hennepin County Courthouse, many years. And there is process that needs to ensue. And there are clients of mine who are the collateral damage of the treatment of me for all these years. And you know what? I withstood it for 10 years. And at some point, I couldn't take it anymore. And I'm human. But if you read this rule to immediately take my license, that's got to be 28B. Never been found, never been requested. The director's not even asking it. I have a state property right in my license. No one seems to want to address that issue. I have a right to a pre-deprivation hearing before you take my property. Otherwise, it's like saying, oh, she's disabled, let's take her house. I mean, they've already destroyed my reputation, and they've already destroyed my business. And then they went for my body, and they've been working on that for a long time, and they finally destroyed my body. And I ask you today, is that protecting the public? Is that how we protect the public in this justice system? We let judges take down any lawyer who stands up and reports truthfully what they see and hear, has documentary evidence this high showing the judicial misconduct. Do we let the lawyer get dragged through the system? When the lawyer's on full disability leave, we let the office serve them with a public proceeding. Aha! Now you're in a proceeding. Now 28C. Can't be the way we look at this.
Clark, I
Yes.
have a question about your position with regard to your medical records that could be submitted under seal and used by the referee to make a determination. It sounds to me that you are arguing in favor of a process that would allow for a reasoned determination as to whether or not you should be placed on disability status. And I'm asking about your position with regard to whether those documents have been provided, medical documents that the referee could use, and whether the process under Rule 28 would allow for those documents to be submitted under seal for consideration
Thank you, Your Honor.
confidentially.
I want to be clear, we stand on all the written submissions. We're not laboring recusal, disqualifications, all that. No, I don't think there's any basis under these rules and under the record to do anything from this point. But if the court was going to do something to pursue 28C, which is the only subsection the director is going after, then you have to have, under federal law, you have to have a pre-deprivation hearing. That's not just my idea. That's federal law, and that's my property right. So you have to have a hearing. I'm glad you brought up confidentiality. My confidentiality has been dragged through the dirt. Craig Klausing regularly would give my confidential documents to Mr. Vasily, who would give them to Zimmerman, who would then apparently give them to Johnny Northside. I was told that the proceedings before Referee Seibel in the first place were confidential. I see it on the blogosphere. My letter that I wrote, that Diana Longry wrote with me about the seizures, we thought that was confidential. And we called Seibel's chambers to confirm that. We see that on the blogosphere. So we need a little bit more than submit them under seal. Anybody can open an envelope and give them to somebody, and then I see them on the blogosphere. I don't feel safe in this system when I'm being treated like that. Craig Klausing was ordered by Vander North that all of the exhibits from the probable cause hearing were sealed. I have emails showing that they were hand-delivered over to the attorney for Mr. Zimmerman. When they're under seal by the referee, under seal, Vasily writes an email, can I get the exhibits? Why, sure, we'll hand-deliver them to you. They were under seal. It's not safe for me. Not me, not Jill Clark, who's apparently a class of one.
Then seek an ex parte sealed review by the referee of your medical documents. Is that correct?
That's an idea. That is an idea. I don't distrust Referee Seibel, but I think it needs to be very, very clear. I do distrust Mr. Klausing. I have about 25 examples of him violating my confidentiality to date. So no trust there, sorry. But I think the idea of ex parte review under seal is an idea. Thank you.
Thank you, counsel. Mr. Klausing, you have 10 minutes for rebuttal. Thank you, counsel, for your arguments. This matter will be taken under advisement, and a decision will be forthcoming.